We have quite a few people joined in. Sanjeev, yeah, I think you can start. He's talking on the sexual harassment at workplace, which has been, it was always an issue, but somehow most people, including the regulators, never got to talk about it. Call it social stigma or legislative sort of non-action or general apathy towards these ticklish issues. But I think in the last few years there have been a lot of initiatives, some good, some bad, mostly good, at least in the right direction. A lot of ground is yet to be covered, but whatever we can and we have done is something we should always know. And there is now a fair amount of regulatory framework also there. Of course, the regulatory framework can't change the way people think, but at least it can give in some form of redressal, give in some form of legitimacy to the action against such harassment. But let's see. Sanjeev, yeah, all yours. We are all
Yeah.
ears.
So, good morning, everyone. Now, with all my informal friends, informal colleagues, informal nears and dears, I'm becoming formal from this moment, from the next moment onwards. My time is starting up. First of all, I have to touch upon the parent language of the Act 2013, whose title is the sexual harassment of women at workplace within bracket prevention, prohibition and redressal Act 2013. I am repeating it just for benefits of everyone to understand the parent language of this act. Heading of this act, the sexual harassment of women at workplace within bracket prevention, prohibition and redressal Act 2013. It has got sexual harassment in our country has always been a very burning issue, burning problem for years together, for decades together. First of all, let me tell you that earlier also there used to be the cases of sexual harassments at the workplace, especially with women. But at that point of time, because of the societal conditions, because of the cultural conditions in India, the women never used to come forward in order to speak out that what has been happening with them or what has happened with them. So that used to be a problem. There is one important aspect that earlier the women were not very active in working outside their homes, outside their families, particularly in the different establishments. And only on the occasional basis, we used to find certain women working either as teachers or somewhere for labor work. And of course, in the elite class of the society also, there used to be certain women who used to work in different fields. But slowly and surely, the women started working in all the facets of the employment. You can find women working now literally in every field, in every facet of the life. So the sexual harassment was that used to be there earlier also, but it got increased because of the changing in the mentalities of the people, particularly in males, in men, and in boys. The moral standards of our country got westernized, and therefore also the sexual harassment cases got increased. So first of all, let me tell you that sexual harassment is called with this nomenclature in India, but in Italy, a European country, sexual harassment is called as a sexual molestation. In another country, France, it is called sexual blackmailing. In few states of Canada, a big country of the Northern America side, it is called sexual solicitation. And in Netherlands, that is Holland, another European country, it is called unwanted intimacy. So different nomenclatures are there, and I could only read while making research. I could only read about such nomenclatures. I had never been a part of that particular site. Please don't mind. Sometimes in the year 1997, on 19th October 1997, Supreme Court delivered a very detailed and an exhaustive judgment in Vishakha versus State of Rajasthan. It is reported in with first of all, let me request all my learned younger brothers and sisters. All my young friends are requested to note down the citation. This is Vishakha versus State of Rajasthan, reported in 1997, within bracket 1997, volume 6 SCC, page number 241. It's a 3 judges bench decision, and the judgment is authored by the then Honorable CJ, Justice J.S. Verma. It is a very, very exhaustive judgment. At that point of time, any legislation was not even there. Any separate legislation was not there so as to protect the women from sexual harassment at the workplace. But Supreme Court decided this particular matter after taking into account so many constitutional provisions in our country as well as in the country, in outside countries, all kind of international conventional standards for rather in against of the discrimination on the basis of the sex. The on the gender discrimination, many international conventions were there. International standards were also framed. They were adopted by the country. Those standards were discussed in details in this judgment of Vishakha versus State of Rajasthan. And you will wonder that in particular judgment of Vishakha, Supreme Court took note of so many things that even the sexual harassment was defined. Many facets of sexual harassments were considered during the course of the submissions. And ultimately, the sexual harassment was defined with 5 particular points. And you will wonder further that those 5 points, as it is, as they were taken as a definition of sexual harassment in the act which came into force much late in the year 2013, on 9th December 2013, in the form of the enactment, Central Statute. I will come to that part later on. And regarding history, let me tell you, in the year 1988, in July 1988, one incident took place which attained the attention of the entire public of India. There was one lady IAS officer. Her name is Rupan Deol Bajaj. She was a special secretary of finance in Punjab government at that point of time. And in those days only, there used to be Director General of Police, DGP, Mr. KPS Gill, Mr. Sardar Kanwar Pal Singh Gill. He was holding number 1 position in police as a Director General Police. The incident occurred in some party which was thrown by some other IAS officer, some other bureaucrat. And dinner was going on. And The allegations were that Mr. KPS Gill, in intoxicated conditions, he was not in normal state of affairs at that point of time, and he asked Mrs. Rupan Deol Bajaj, that Special Secretary Finance, to sit beside him, and he tried to fetch that particular chair nearest to his chair, and thereafter he tried to molest that lady IAS officer. After 11 days, she filed FIR against that particular Director General Police, Mr. KPS Gill, and allegations were of the sexual molestation, sexual harassment. This matter has got a checkered legal history, and matter went up to High Court. First of all, for quashing of the FIR, KPS Gill filed petition under Section 482 CRPC. We have been dealing in we all have been dealing in these kind of matters day in and day out for the quashment of the FIR. The FIR was, I would like to say, surprisingly quashed also by Punjab and Haryana High Court. Then the victimized lady officer, Rupan Deol Bajaj, filed appeal before Honorable Supreme Court to challenge that impugned judgment of the Punjab and Haryana High Court quashing the FIR. At Supreme Court, she succeeded, and in a very categorical manner, in the judgment authored by Justice M.K. Mukherjee in the year 1995, very categorically, Supreme Court said that this is not a case of the quashment of FIR, because prima facie there was an ample evidence of sexual harassment, and therefore the courts concerned have to look into the things afresh. That judgment was delivered by Supreme Court in the year 1985. Again, all my younger friends are requested to note down the citation. This is within bracket 1995, volume 6 SCC, and page number I will just let you know after some time. I'm sorry, I could note down the page number. It is within bracket 1995, volume 6 SCC. I will come out with the page number. But so far as this particular statute, that sexual harassment of the women at the workplace, Act 2013 is concerned, the incident between Rupan Deol Bajaj and KPS Gill, that incident did not occur at a workplace. This important aspect you have to keep in mind, that it was a case of sexual molestation, sexual harassment, but essentially it was the home of some other IAS officer, where on the private basis he had invited all other bureaucrats, including the victim lady, including the Director General Police, on whom allegations were there, in a private party. So naturally it was not a workplace. Although the argument was there before High Court, before Supreme Court, that since the two were known to each other because of the working although in different wings in the Secretariat of the Punjab government, therefore it can be said to be a workplace. But this argument was negative, and rightly negative, by Supreme Court. Thereafter, I am coming back on the judgment of Vishaka. Vishaka's judgment is quite lengthy, it is quite exhaustive, and as many as 12 guidelines have been issued by Honorable Supreme Court through the reason CJ who authored the judgment. Those 12 guidelines were taken note of, but very surprisingly, and rather it is not a surprise also, we can say it from another angle. For years together, Government of India did not do anything, because there were the allegations that for government these kind of things are always last priorities. Then sometimes in the year 2012, in October 2012, there was a judgment of Medha Kotpal Lele versus Union of India. That was again a 3 judges bench decision authored by Justice R.M. Lodha, the then judge, the then senior judge, and later on he became CJ of India also. It was taken very seriously that government has not done anything for creating a proper legislature to prevent and to prohibit the sexual harassment of the women at the workplace. And strictures were also passed by the Supreme Court in that judgment of Veda Kotwal Lele. You all may kindly note it. It is within bracket 2013, volume 1 SCC, page number 297. It's a 3 judges bench decision authored by Justice R.M. Lodha. And after passing of such kind of strictures within a period of 7 months, in April 2013, the act was enacted, statute was enacted, its nomenclature was given, what I have already submitted before you all. And within next 6 months thereafter, the rules of 2013 were also framed to make the entire statute workable. Friends, you already know it very well that every act can be made workable only by way of framing of the rules. And framing of the rules is done in the Constitution by way of the constitutional powers conferred by the Constitution of India. So within a period of nearly 14 months, rather less than 14 months, after the judgment of Medha Kotwal, the act came into the effect. This act of 2013, along with the rules 2013, were made effective from 9th December 2013. And in this act, 4 essential ingredients are there. Number 1, sexual harassment. Number 2, sexual harassment on women, sexual harassment to women. And number 3, that it has to be there at the workplace. Workplace definition is also very wide. I will come to that later on. And 4th is how to prevent it, how to prohibit it, and in case prohibition or prevention could not be there for whatever reason, then how to redress and how to give the redressal to the victimized woman. So these 4 are the essential ingredients. I am repeating: sexual harassment, number 1; women, number 2, who are subjected to sexual harassment; number 3 is the workplace; and number 4 is the preventive measures, prohibitory measures, and the redressal measures. You can take it jointly. That 4th ingredient, you can take it jointly. Now, first of all, friends, I am asking whether I am audible. May I get some feedback from you, whether everyone is properly listening to what I am saying?
Yes, sir. Yes, sir. We all are able to listen properly.
Am I audible?
Yes, sir.
Okay. With your permission, I am proceeding further. Now, I request everyone to look into the provisions of this Act 2013. It has got 8 different chapters, which are Roman 1st, Roman 2, Roman 8. Just 1 second. Roman 1st, that covers chapter number Roman 1st. It covers section 1 to section 3, and it covers section 2, which is very exhaustive regarding the definitions. Many definitions have been given, but my request is to see 2 definitions which are most important. One is sexual harassment, which has been given in section 2 within bracket N, and just next definition is section 2 within bracket O, that is the workplace. You may see that sexual harassment has got 5 points within section 2N. And now I request you all to recall what I said. I have said just 7-8 minutes back, that section 2N has taken the definition of sexual harassment literally as it is what has been given in Vishaka's judgment of Supreme Court. You may note it. Then you come to another definition, that is workplace. At this juncture, I will like to say that there is clause Roman 5th within section 2N, within section 2O, which speaks about the workplace. May I request you to see this clause Roman 5th? It speaks about the touring side, when a woman along with some male person on behalf of the establishment is on the tour and is during the journey as well as at the place where both are staying, if any sexual harassment takes place at the behest of the male with that particular woman, then whether it will be called as a workplace? Yes, legislature has taken full care of all that. It is coming within the purview of the workplace. I quote one example. At an establishment at Jodhpur, there is a woman employee and there is some man also. That one man and a woman both are sent by the establishment for some official tour to Delhi. From Jodhpur to Delhi, both are in the journey, both are in the train, and in case any sexual harassment is done on part of the male, and that woman is subject to that harassment, sexual harassment, then it is very much within the definition of the workplace, because for work only, for the official work only, the two have been going to Delhi, and that the mishap is being done during journey. So this is also covered. If at Delhi both stay in some hotel, and if any sexual harassment is subjected by the male to a woman, then also it is within the extended definition of the workplace. Then there is a chapter 2 which speaks about the constitution of the Internal Complaints Committee. Friends, it is very much necessary that in order to look into the allegations, in order to look into the complaint filed by a woman, whether there is any veracity, whether there is any truthfulness with that complaint or not, whether for any ulterior motive a woman has simply tried to implicate the male. All these things need to be looked into departmentally, and therefore Internal Complaints Committee, that particular chapter is there in chapter 2, and section 4 is there. Section 4 has got its utmost importance. I will come to certain judgments thereafter. You can see that how important this legal provision is. The next is chapter Roman 3, which speaks about the constitution of the Local Complaints Committee. This is one thing what has to be ensured by the government. The establishment hasn't got any control over this particular provision of section 5 to section 8. These 4 provisions under the chapter 3, Roman 3. These 4 provisions are meant for the constitution of the Local Complaints Committee. Again, you need to look into these particular 4 provisions also. The interest of women, interest of victimized women has been watched very thoroughly and very exhaustively in both these chapters, because the mechanism, maybe in the Internal Complaints Committee, maybe in the Local Complaints Committee, a full representation and substantial representation has been conferred on the women only, so that in a male dominating society, any woman is not made remediless in case she is subjected to sexual harassment. She has to be ensured mentally and by her that her interest is being watched fully and exhaustively by these committees. Then next is chapter Roman 5th that speaks about the complaints. The operative part starts coming into the picture with this section 9 to 11 are meant for the complaints, how the complaints are to be dealt with, and in what manner complaints are to be decided, and according to the decision, what further action the employer has to take under these provisions that has been enshrined in this chapter Roman 4th. Now I request you all to see chapter Roman 5th that speaks about the inquiry into complaints. This is also a very important chapter. Section 12 to section 18 are there. And now, in case you have got the act in front of you, I can request you to see that section 12, that is the action during pendency of the inquiry. Section 13 is for the inquiry report, quasi-inquiry report. Section 14 is the punishment for false or malicious complaint and false evidence. This is very important, that in case committee finds, in case the inquiry comes out with the result that a complaint filed by the woman was malicious, it was to implicate a male fellow unnecessarily for whatever other reasons, for maybe for settling the private scores, maybe for other kind of harassment, maybe for the vengeance against him, for whatever other reason which has already become part of the history, part of the past. So when there is any false or malicious complaint on part of filed by the woman, then punishment has been provided under section 14. Then section 15 is for the determination of the compensation. I invite your attention towards the title of the statute: prevention, prohibition, and redressal. And the third part of the fourth ingredient, that is redressal, that can be equated, that can be compared with the determination of compensation under section 15. Then section 16 speaks for the prohibition of the publication of making known contents of the complaint. See, in our society, the history speaks that because of the family's reputation, in order to make family's reputation intact, there used to be most of the women never coming out with the truth of sexual harassment with her or with them. Sexual harassment once becomes a matter of public, that particular lady was sexually harassed, she is always looked down by others. People normally don't come for their rescue very openly. Although people have got the sympathy with the women who are subjected to sexual harassment, nevertheless, in our societal and cultural conditions in India, women don't want it to be publicized much. That has been ensured. Prohibition of publication or making known contents of complaint and inquiry proceedings. That is ensured in section 16. Then section 17 is the penal provision, that is penalty for the publication. We can skip it for the time being. Then section 18 provides for appeal. Then section 19, that comes with the duties of the employer. Again, I invite your kind attention towards Vishaka's judgment. In that, there were 12 guidelines issued by the Supreme Court, that in what manner they have to take care, what manner the employer has to take care, what kind of duties employer has to perform towards prevention, prohibition, and the redressal of the sexual harassment. So now, from small a to small j, different duties have been cast on the employers. That is section 19. Now I am coming to chapter Romans 7. That is duties and powers of the district officer. District officer is already a part of the this local complaints committee. It is for that only. Then there are two sections of the there is section 21, that is the committee to submit the annual report of whatever has been done in order to further and in order to propagate the legislative intention behind the Act 2013. Then some other miscellaneous provisions are there. Then penalty for non-compliance with the provisions of the Act. That has also been enshrined in section 26. In all, there are 30 provisions, 30 sections within the Act 2013. Friends, now it is high time for me to come for certain judgments. But before coming to the judgments, I will like to submit here and to address here on the constitutional provisions. Article 14 of the Constitution is number one article, which is famous for the purpose of filing the writ petition. We all know it very well. It speaks for equality. It's a backbone of section 226, article 226 for filing the writ petition. Section 14 is there, but for the purpose of present statute, article 15 is more important. Article 15 speaks for the prohibition of the discrimination on the basis of religion, caste, race, sex, and place of birth, etc. At this juncture, I would like to tell you that sexual harassment basically is an outcome of the gender discrimination. Gender discrimination has been prohibited expressly and impliedly both by Article 15 of the Constitution of India. So, for the purpose of sexual harassment, it has to be understood that Article 15 and the compliance of Article 15 has to be ensured by our country, maybe through the courts, maybe through the parliament, maybe through the executive actions. And then Article 19(1)(g) is basically general for no discrimination regarding practicing any kind of profession or like that. But this Article 21, that is more important here. Article 21 that ensures, just one second. Article 21, I'm going to that. I want to use the exact language as such. Article 21 is the protection of life and personal liberty. The protection of life and personal liberty, it is for all. It starts with no person shall be deprived of his life or personal liberty except according to procedure enshrined by law. So women are also part of it. So Article 21 of the Constitution of India has to be coupled with Article 15 and Article 14. And we all have to ensure, and this Act 2013 essentially stands enacted to ensure that all the constitutional provisions which I have just narrated, they all have to be complied with properly, exhaustively, and in entire manner as possible. Now the last part of my lecture is again quite detailed one. That comes from the judgments. But slightly, I will like to touch Section 509 of Indian Penal Code. This is very important, that the word, gesture, or act intended to insult the modesty of a woman. So Section 509 of Indian Penal Code, that is one penal provision besides many other penal provisions, but it is quite near to the sexual harassment, because the word, gesture, or act intended to insult the modesty of a woman. So Section 509 is quite important for this subject of sexual harassment. Of course, there are many other provisions, but I will not try to narrate them unnecessarily. Now I'm coming to the last part, that is the part of the judgment. Vishaka's judgment I have already touched upon. Thereafter, in the year 2012, in October 2012, another 3 judges bench of decision of Supreme Court was there, authored by Justice R.M. Lodha, in the matter of Medha Kotwal. That these 2 judgments I have already touched, but a very important judgment was delivered sometimes in the year 1999 beginning, and that judgment is Apparel Export Promotion Council versus A.K. Chopra. It was reported in the year within bracket 1999, volume 1, SCC. I'm just submitting the page number 290, page number 759. This is a 2 judges based decision authored by Justice A.S. Anand. At that point of time, he was CJ of India. This judgment is very important because it covers both the aspects. It covers all those aspects which was touched upon just 2 years before in Vishaka's judgment, and at the same time, it comes out with all kind of facts involved in that particular mishap. One lady officer working in Apparel Promotion Council, she was subjected to the sexual harassment, and the allegations were there on one person, Mr. Chopra. Mr. Chopra tried to harass her sexually, but he could not succeed in getting it done. Anyway, complaint was filed by the lady, and the inquiry committee as well as disciplinary committee both came to the conclusion that Chopra was guilty of the sexual harassment extended to the lady. That fellow filed a writ petition before Honorable Delhi High Court. The single bench of Delhi High Court allowed the writ petition on the ground that sexual harassment, although was tried at the behest of that particular delinquent, but he could not succeed it because there was no physical contact or physical touch. So he was ordered to be reinstated in service. Very surprisingly, the division bench also agreed with that and upheld the single bench judgment of Delhi High Court. But subsequently, when employer came before Supreme Court and the judgment is Apparel Export Promotion Council versus A.K. Chopra, within bracket 1999, volume 1 SCC, page number 759. Supreme Court reversed both the single bench judgment as well as division bench judgment of Delhi High Court with the conclusion that physical touch as such is not necessary. It can be done even by gestures. If by way of words, if by way of other kind of insults in order to sexually harass someone, if those things are proved, then physical touch or physical contact or physical molestation by using some hand or anything else, any part of the body, that is not necessary. The sexual harassment is proved even without physical touch, without physical contact, and therefore both the judgments of Delhi High Court were ordered to be reversed by Supreme Court. The Apparel Council's appeal was allowed. Please read that particular judgment thoroughly because it touches all the aspects, factual aspects, human psychological aspects, as well as the legal points which were already touched upon by the judgment of Supreme Court in Vishaka. After enactment of Act 2013, there were certain judgments, and because of shortage of time, I will like to tell you here, like to request here, that few judgments of Delhi High Court, two judgments of Delhi High Court, two judgments of Bombay High Court, and one judgment of Honorable Rajasthan High Court, that needs those judgments need to be looked into. First of all, I am coming to Rajasthan High Court judgment. We all belong to Rajasthan, and naturally we have got more inclination towards the Rajasthan High Court judgment on this subject. But in Rules 2013, which were framed along with the Act of 2013, Rule 9 speaks that what is to be, how the service of the person concerned on whom allegations of sexual harassment are proved, how that service, what the service, how will be affected or resulted. That is spoken by Rule 19. Then in case other service rules are not there, then Rule 9 will come into picture. So there is one judgment of Rajasthan High Court, that is a single bench judgment at Jaipur bench, authored by Justice Ashok Kumar Gaur in the matter of Sheetal Prasad Sharma versus State of Rajasthan. And all my young advocate friends are requested to note down, this is 2018 SCC Online Rajasthan 759. This is a single bench judgment. The writ petition of it was a service matter. Writ petition of Sheetal Prasad Sharma was allowed as such. Sexual harassment was proved against him, but Rule 9 of the rules of 2013 could not have been resorted to because there were already existing service rules within the rules meant for that available in Rajasthan statutes. Therefore, the petition was allowed with this limited aspect only, that Rule 9 cannot be resorted to in the given facts and circumstances. Now, let us see another judgment of Saudi Arabian Airlines versus Shehnaz Buddh Bhatkal. There were two judgments in this case. The lady was working in Saudi Arabian Airlines. Her husband was already working in Saudi Arabia only. She used to travel between India and Saudi Arabia. She was working in Saudi Arabian Airlines, and sexual harassments were there. And because of sexual harassment and because of another threat that her husband will be kicked out from service in Saudi Arabia in case she doesn't accept the sexual advancements of the certain male officers within the airlines. Under that threat, under that severe mental conditions, the lady functioned. Ultimately, she had to file complaints, and under the threat, once she submitted a letter of apologies also to the airlines. Please look at the height of the illegalities committed in the garb of sexual harassment. But ultimately, Justice B.N. Sri Krishna, as he then was, later on he became Judge of Supreme Court, Justice B.N. Sri Krishna delivered SB's judgment in favor of that lady against the Saudi Arabian Airlines, and imposed the cost also, heavy cost, on the airlines. Thereafter, research says that it was that single bench judgment of Justice Sri Krishna was upheld by Honorable Division Bench of Bombay High Court, but the reporting thereof, I could not lay my hands upon. So SP judgment is reported in 1997. You may note down 1997 SEC Online, Bombay 508. It's a very detailed judgment and worth reading it. Now I'm coming to two judgments of Honorable Delhi High Court. One is Ruchika Singh versus Air France India. Another is Shanta Kumar versus CSIR. The Shanta Kumar versus CSIR is a judgment delivered in the year 2017 by a single bench presided by Justice Vibhu Bakru. It is 2017 SEC Online, Delhi 11327. The background story is that a male, during heated exchange amongst all the staff members, in the presence of other staff members, he simply held the arm of a lady. But that was during the heated verbal exchanges on some subject which was already going on. And it is further said that that male was basically a short-tempered fellow. And during that heated exchange of the oral arguments between the staff members, he held the arm of a lady, Mrs. Shanta Kumar. Lady filed a complaint, and the inquiry was conducted, and inquiry was concluded that any sexual molestations mentality was not there. It was only during the verbal exchanges, and the only incident of touching anybody's arm for any woman's arm for the first time, and that also on some subject that doesn't tantamount to sexual harassment. And Delhi High Court, single bench of Delhi High Court, also upheld and did not like to interfere the factual findings of the inquiry committee. That's what, in that from that point of view, this judgment carries great importance. And another judgment of Air France India, that is of 2018 as such. It is Ruchika Singh versus Air France India. It is reported in 2018. SEC Online, Delhi 9340. It's a DB judgment authored by Justice S. Ravindra Bhatt, who later on became CJ of Rajasthan High Court. This judgment is very important judgment in a way that it covers it relates to the constitution of the Internal Complaints Committee. Section 4 needs to be looked into for the purpose of considering this judgment. In that committee, certain important mandates were not complied with, and in order to make the entire case subsided, one committee was formed by the Air France India by not strictly following Section 4, and that constitution was challenged by way of writ petition before Honorable Delhi High Court. Honorable Delhi High Court disposed of the writ petition by accepting the submissions advanced on behalf of the victimized woman, and held that the committee was ill-founded, that committee's recommendations were quashed, and the matter was remanded back by Honorable Division Bench of Delhi High Court to constitute a committee afresh and thereafter to proceed with the matter. Now that judgment part is also over, but it is necessary for me to tell you all that essentially there are not two parties only in sexual harassment cases. There are three parties. One is of course a woman who is subjected to sexual harassment. Another party is the male who committed such sexual harassment, who extended such sexual harassment. And third is the employer. Because please see, the ultimate result is not only the inquiry so as to hold whether sexual harassment took place or not, but it goes further, that what will be the future of the service of the person who committed this kind of offense. So whenever you come across the judgments arising out of the sexual harassment, then it is quite necessary to look into the service matters also which arise out of this sexual harassment. It is unfortunate for our country that despite making of the law in the year 2013, even the incidents of sexual harassments have been increasing only. The moral standards decay, that may be one reason for that. Another reason is that people are not becoming conscious nowadays regarding their proper dressing sense. People forget many psychological aspects, that the congenial atmosphere at the workplace, a good relations between boss and the lady worker working under him officially, that what are the bounds, what are the parameters beyond which it will be a sexual harassment. So the congenial atmosphere doesn't mean that you will transgress your limits. You have to be very conscious about your carriage, about your disposition, about your conduct as such. Your conduct should always be as such that it not only transgresses the limit, but it should appear also that male concerned is not transgressing his limit. Congenial atmosphere has to be maintained by the employer, by every male, and even by women also. Because so far as dressing sense is concerned, my humble opinion is that it goes equally good for men as well as women. And such kind of parameters need to be ensured religiously by the employers. The Act 2013 is quite exhaustive. All kind of psychological aspects need to be adhered with in a manner that you don't transgress your limits. Friends, I am very much delighted to submit here that I am at most thankful. I'm really thankful to you all that you gave me this chance first to speak out on this important subject, which is the burning issue in the entire country. And I don't know whether you enjoyed it or you tolerated me while speaking on this subject, but I tried to cover very many issues. I tried to look into not many judgments. I tried to research, and I'm thankful to my colleagues, including the organizer, Mr. Sanjeev Gupta himself, and my two juniors, Mr. Lalit Parihar and Shubhankar Johari, who incidentally happens to be my son also. Anyway, I'm quite thankful to you all, and you may or may not forgive me in case I have said something wrong, or I have said something exceeding my limits while speaking on this subject. May I know that may I invite any one of you or all of you in case you want to ask any question or any questions for that.
Anyone, do you have any questions? Sanjeev, it was entirely our pleasure to have you. Really good to have you as part of the legal sphere discussions. We've always tried to get in some academic discourse.
Hello. I'm sorry. Hello, because I'm sorry for
Yes,
the interruption. I just forgot to extend my thanks to you.
come
That
on.
oh, just a second. I'm senior to you. Because I'm senior to you. That's why you tolerate me. You please tolerate me for a minute more. What I'm telling you is that in the year 2001-2, when I was one of the office bearers in the Rajasthan High Court Advocates Association, we started one academic program and continuous academic program. At that point of time, Mr. M.R. Singhvi, senior advocate, used to be the president, and Justice P.S. Bhatti used to be the general secretary. In that particular period, we tried to launch academic programs for whole of the year. We wanted to get it done every Saturday, but we could succeed in getting it done twice in a month only. And that program was academic programs were appreciated. And because I'm really thankful that you reminded me with your launching this particular series. This is going to give great results, I tell you. It is going to be a good atmosphere, healthy professional atmosphere amongst all of us, and particularly the young advocates. I'm really thankful that maximum young advocates have been participating, and that's a matter of great sign. Now,
Thank you,
I'm
Sanjeev. It's always nice to hear words from you. We have a question. Pragya has a question. Pragya, could you go ahead and ask?
Good afternoon, sir.
yes, good
Am I
afternoon.
audible?
Yes,
Yes.
yes, you are good.
Sir, quite recently, I mean, not so long ago, there was this case in the Supreme Court which got us all thinking whether courts would also fall under the definition of a workplace as defined under this Act of 2013.
Yes. In my humble opinion, the courts are within the definition of the workplace, but there are two things which need to be looked into. After particular incidents, when the two girl interns leveled allegation on the two Supreme Court judges in different uh, incidents or in the series of incidents, and that became those became talks of the entire country. Sometimes in the year 2011 and thereafter, second in 2012 December. Then Supreme Court has already framed the regulations, and regulations are. I'm just coming out with that particular name. Just 1 second. It is the gender sensitization and sexual harassment of women at the Supreme Court of India within bracket prevention, prohibition and redressal regulations 2013. So those regulations, if you look into, you will find that even at Supreme Court also, the court has been held to be a kind of workplace only. But at this juncture, I will like to tell you one more thing. Before you ask any other question, let me give the answer exhaustively. There was another judgment there was another incident of the sexual harassment in Madhya Pradesh High Court. I don't want to name the city. I don't want to name honorable judge's name also. Uh, there was one additional district judge, a lady, who leveled the allegation against a sitting senior judge of Madhya Pradesh High Court. That matter came up. That matter came up before Supreme Court, and Supreme Court, in a judgment of additional district judge versus Judge X, who Registrar General of MP High Court. That was a judgment reported within bracket 2015, volume 4 FCC. Again, I will just come with the page number, that is 2015 volume 4 SCC, page number 91. That is the two judges bench decision authored by Justice J.S. Kehar. The in-house committee, how it was to be constituted, that was the conclusions arrived at by Honorable Supreme Court. Keeping in mind that since it's a matter of the reputation of the reputation of the court, that is why the in-house committee should be constituted in such a manner that both the sides, the victimized lady as well as the judge against whom the allegations are there, both these sides may get the entire justice with proper opportunity of hearing. So courts are very much within the purview of the workplace, according to my humble opinion, and that is why only the regulations were framed by Supreme Court, and that's why only the Supreme Court judgment was also delivered in that Madhya Pradesh High Court case, and in that case also some other relevant aspects were adjudicated. Yes.
I just add on to that, Pragya, it's a very pertinent question. And in fact, if you ask me, the reason why this question comes up is because courts, they're the ones who decide and interpret. They're not willing to see the reality of life and still want to leave this question open. But even if we see the definition, if something is funded by the appropriate government, then it is a workplace. And the courts, see, the judges' salaries do come in from the constitutional functionaries that the judges are, High Court and Supreme Court. Their salaries come from the consolidated fund. But the budget of the court itself comes in from the appropriate government. It comes from the government. So there is no question of why the courts would not be a workplace and not falling under this. Of course, I'm saying this with a caveat that one never really knows how the courts will look at and find a unique way of interpreting it, because we fancy ourselves on distinguishing. But if you ask me, it's very clear they are workplace. There's just no going away from it, and rightly so. In fact, if the definition did not include them, then it's a faulty definition for all purposes. The debate and question would come in not whether they are workplace or not, but who all would be subject to the jurisdiction of that workplace, in the sense that all the employees, of course, there shouldn't be any problem. All people who are deriving their salaries from that place also would not be a problem. But what happens who are visitors to that place, whether as lawyers who are court officers or litigants who have just come in for their work or for meeting someone, and they being public places, even just people walk in and walk out. They are strictly not employees, but lawyers, clerks, and people whose cases are listed. There the issue would be whether they would come under the court or not. If you ask me personally, yes, they ought to be, because they are, for that particular period of time and for that work, they're directly part of the work of the court. But that's, I think, I'm not sure if there's any judgment on it or if the debate is still on. But I think that's the issue. Salman had a question, and Salman, that was an extended question. Can you just go ahead and ask?
Good afternoon, sir. Sir, my
Good
question was basically in furtherance of the question of Pragya ji. So, if there is formation of an in-house committee, so in that cases, whether the in-house committee will constitute only the judicial members or any member of outside of the judiciary, like any member from NGO or any member of the women representative group.
Salman, please see section 4. Section 4, that is the Constitution of Internal Complaints Committee, and the entire constitution has been given in a very elaborated manner, and the judgment of Delhi High Court, which I had referred to in the matter of Ruchika Singh, in that judgment, this section 4 and the constitution of the Internal Complaints Committee under section 4, that had become a matter of subject, and therefore the Internal Complaints Committee as such, which has been properly defined, the mandates, legal mandates have to be adhered with. Let us read it Have you got it with you just now?
No, sir, I don't have it.
Salman, have you got
No,
it?
no, sir, I don't have it right now.
You don't
I
have.
am
Okay,
listening, sir.
okay. I'm coming out with certain things. The Constitution of Internal Complaints Committee, subsection 2 becomes more important for the purpose of your question answer. The internal committee shall consist of the following members to be nominated by the employer. A presiding officer who shall be a woman employed at a senior level at workplace. From amongst the employees, provided that in case a senior level woman employee is not available, the presiding officer shall be nominated from other offices or administrative units of the workplace referred to in subsection 1. Then further proviso is there that provided further that in case the other offices or administrative units of the workplace do not have a senior level woman employee, the presiding officer shall be nominated from any other workplace of the same employee or other department or organizations. So all those things have been taken care of. And at the very initial stage of my addressing today, while touching certain facets of the statute, I had submitted, conveyed that the interest of the women had been voiced throughout exhaustively and in a very qualitative manner.
Thank you, sir.
We have another question from Shambhavi. Can you hear us? Go ahead.
Hi, good afternoon, sir. So I don't know how relevant this question is after what Pragya asked, but I'm gonna anyway ask and go ahead with it. We
Yes.
don't have a sexual harassment cell in the court premises. At least I'm not aware of it, and I don't know many girls who know of it. How and what steps on a practical level can we take to build one in our court and make it an active and safe one? And I'm not speaking of a cell that would cover the judges. I mean lawyers, complaint against the lawyers. How can women have a cell that can address their issues?
Yes, it's a. Let me tell you first of all that you are coming directly on the redressal point. It is better to see that how successful we all are in prevention and in prohibition. It appears to me that yes, at times we don't come across many things because many a times in institutional interest, lady advocates do ignore such kind of things to come out with the incidents. Anyway, my suggestion is that we all can sit together sometime and thereafter we can have some kind of internal system by proper deliberations, because presently, so far as lawyers side is concerned, yes, we don't have any such kind of mechanism framed particularly for the subject of sexual harassment on lady lawyers, subjected maybe by other male advocates or maybe by other staff members of the courts or like that, or even by litigants. Yes, we don't have any such kind of internal mechanism framed particularly for the advocates.
So Shambhavi, this is a classic case of Chirag Tale Andhera. You know, the courts which are meant to be the final recourse of redressal of such issues themselves have not really taken care of seeing their own internal things. And that is not surprising at all, because for most things, courts have been the sort of torchbearers for the rest of the society, but they've never been inward looking. And even things like, until we were housed in the last court, you had no, say, a fire escape mechanism if the building caught fire, and the law was very clear that there was an absolute liability for the owner of the establishment in case something like that breaks out. You know, the famous cinema hall case where the directors of the company ended up going behind bars. Would this have meant that if, because they had not taken care of a fire escape, Would that have meant that the Chief Justice would go behind bar if tomorrow if something of that had happened in the earlier building? The new building, of course, had all those equipments. It's a very similar situation that though you are governing the rest of the world, but your own internal mechanism is not in place because they've either not had the time or nobody has pointed out that this requires to be done. What needs to be done would actually depend on the answer to Pragya's question, and what I briefly pointed out, that whether lawyers would come under the jurisdiction of the court being a workplace and everybody subjected to this. If yes,
Right.
then your such a cell would be under the aegis of the court itself. If no,
Right.
then possibly the bar association would have to develop something like this under its aegis, because all of us by default are members of, no, sorry, not bar association, I would say bar council. Bar council,
Right.
we are by default all members of the bar council and subject to the guidelines, rules, regulations of the bar council. So it is for the bar council, though sorry to say, in the current scenario, how active they are on serious issues. I don't want to get into that political debate, but it will have to come from one of the two, because if you create a self-appointed cell, I'm not sure how effective would be and what would be the legal sanctity going forward. So ideally, we have to first find an answer to the question whether the lawyers would come under the, so as to say, the court being the employer and a workplace, then it's the court to do so. If not, then either the bar council or the bar association, whomever we decide, and submit to jurisdiction for such issue. But yes, it has to be there. It ought to be there. It should have been there long ago. But whatever, going forward, I think, well, all of us, sorry, should take this forward when this opens up, and or while we are closed down. Why don't some of you get together to formulate a blueprint of establishing such a center, what its rules, regulations would be, how it would function, and how it will be operationalized. And then when it's open, we can actually then go ahead and give it to the people who can open it up. I mean, that's the best we can do. I think it could be a homework for some of you who are listening in today. It will be a great service to everyone. And with this food for thought for today, I think we need to close, because I think we are running out of time. We can take one small question, last one. Oh no, that's Vanna's comment, I think. Vanna, would you know of it? Can you throw some light on this? We can't hear her. So I'll just read what she has written in. As far as my little knowledge is concerned, we do have a
committee, not aware
of present scenario, though it's not functional. And Justice Mathur was heading the legal aid cell, this committee was formed. So imagine, that brings me to one more question. What sort of a committee and functionality is it when the top women lawyers of this court don't even know about it? I mean, that says a lot about such a committee and the information dissemination which the court is having. I think if something like this is functional, great, but it's even important that everybody knows about it. Jungle mein nacha more kisne dekha? See, all of us here don't even know about it. I mean, it's a huge question mark on how we are sharing information, including the courts. Again, I'm a little sorry to say that, but I think it's something which the courts have to be more sensitive about. All of us have to be more sensitive about. Good. I think we'll close it off here. We're running out of time now. Thank you, Sanjeev, once again, for touching on this such a sensitive issue and important one.
Rather, it's my gratitude to you.
Samarpit, thank you for coordinating. Thank you, everyone, for joining in. Tomorrow we have Shambhavi, who's talking on the international humanitarian law, something which we really don't get to see, only read it in classes, but I think it's high time we get to see that also. World is becoming one. So we'll wait for Shambhavi tomorrow. The next 2 days we'll have Sandeep Shah talking to us, one on writ remedies, and the other one he'll take us through CCA rules, which is very specific subject. And then on Sunday we have Sanjeev talking to us on environmental laws. That's a Mother's Day, so appropriately he wanted to speak on the Mother's Day on environmental issues. And on Monday we have something which is of use to most of us, but we don't end up understanding it. It's very technical also. We will try and understand the documents and terminology under the land revenue laws. That will be Sunil Benewal who will talk to us. And so we have these few things lined up. We'll see you tomorrow, everyone. Thank you so much.
Okay, thank you so much.